Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm Head of Culture and Engagement at Bender Insurance Solutions. We want to welcome you to another educational BenderU webinar, your 2025 Labor Law Update. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I'll be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we'll gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link, as well as a copy of the slide deck, will be forwarded to you. We have an incredible expert sharing with us this morning, and I have the honor of introducing him. Derek Decker practices civil litigation, handles transactional work, and provides day-to-day legal advice to all types of businesses. His focus includes employment matters, which he has handled consistently since 2004 when he was licensed as an attorney. He has represented parties ranging from individuals to multinational corporations, and throughout his career has litigated and tried highly contentious and complicated matters, as well as represented clients before the Department of Fair Employment and Housing, which is now Department of Civil Rights, Equal Employment Opportunity Commission, the Labor Commissioner, and Department of Labor. He has substantial experience representing insurance companies and other institutional clients and understands the advantages gained by knowing your case early and in detail. His policy on employment matters is to protect against and avoid claims before they happen. So without further ado, welcome Derek.
Thank you very much, Jillian. Thank you for that introduction. I hope everybody's doing well. Good morning to everybody. We're going to be going over, as you know, the 2025 employment law updates for California, also from a federal perspective to the extent there's anything changed. There's less changes, I would say, for 2025 than there were for 2024. So we will, I think, have ample time for questions if anybody has them. As Jillian said, as we go along, I'm happy to answer them. And then we are likely to have some additional time at the end. And I also included a few things that are current law and have been an issue for employers in the past, but are likely to continue into 2025. And there's some nuances to some of those issues as well. So without any more wasted time, let's get into it. These are the new laws for 2025 in California. The first one is SB, and I think people probably know, but SB stands for Senate Bill. And then there's also AB, which is Assembly Bill. So this is AB 399. All of the Senate bills and the Assembly bills, to the extent that they've passed, will eventually be incorporated into a statute, which is almost always, in this case, the Labor Code. Sometimes you may see it in a regulation, but SB 399 will eventually become another number under the Labor Code. But right now it's SB 399. So this is the issue of compelling employees to go to mandatory meetings. Now, these are only meetings on certain issues, which are religious or political matters. This new law is going to have employers prevented from threatening to discharge, discriminate, retaliate against, or carry out actions against employees who decline to attend an employee-sponsored meeting, or who decline to participate in, receive, or listen to communications regarding an employer's opinions on religious or political matters. Now, a lot of employers, from my experience from the businesses we represent, don't have a lot of mandatory meetings concerning religious or political matters, right? It's just not something that is that common nowadays, certainly. But the language of this law is relatively broad, and you can see that it says, employers cannot do anything in relation to an employee who does not want to listen to a communication regarding the employer's opinion on religious or political matters. I will also say this at the outset. I am somewhat biased because I'm an employment defense attorney. So I see things from the defense perspective. I have done a limited amount of plaintiff's work, but I will tell you from a defense perspective, um, allegations that go into a complaint can take very broad language and shoehorn a lot of stuff into that. You know, it's not that hard to allege that, hey, my boss or my manager tried to tell me about XYZ that has some religious or political connotation. I didn't listen to it. I don't believe that. I'm on the other side, whatever it might be. And then that becomes an allegation that a employer has in some way retaliated against that employee for not wanting to listen to that communication. So keep in mind, again, this statute and many statutes can be broadly worded, and think about what can fit into that. So, you know, the overall takeaway from this is certainly do not have mandatory meetings that employees need to go to on those issues. Be careful about mandatory meetings where those types of things are even discussed, right? Um, So I think we've discussed that one enough. Here are some of the definitions with it. So religious matters are defined as relating to religious affiliation and practice and the decision to join or support any religious organization or association. Political matter is defined as relating to elections for political office, political parties, legislation, regulation, and the decision to join or support any political party or political or labor organization. It gives some guidance, right? Those definitions, though, to me, are still broad enough that you could fit a lot of things into that. This new law does not apply to mandatory training in which employees are there to comply with an employer's legal obligations, such as obligations under civil rights law, right? If you have to discuss the issues of what is unlawful discrimination, what is unlawful harassment, how do you stop that, how do you report that, things like that, occupational safe and healthy law, um, it does not apply to that. Now, that does not mean, you know, that employers get a free pass, that if you have some meeting covering OSHA issues, you can also go into political leanings or political decisions or, you know, events that are going on. So keep those separated, you know, keep that out of mandatory meetings. Make sure the mandatory meetings, like we discussed, don't contain any material meeting that definition. Again, it gives employees another basis to argue that a termination, a demotion, or a retaliation can be a broader scope of activity than just a termination. Termination, relatively easy to determine, right? The person doesn't work there anymore. Retaliation could be they gave me the cold shoulder. You know, I didn't want to listen to my manager talk about XYZ. And after that, I just didn't get good assignments. Our relationship changed, things like that. So retaliation in California is something we see a lot more over time. And I think again, it's because it has a somewhat ambiguous definition of what constitutes retaliation. The next one is Assembly Bill 2299. These are whistleblower rights. Uh, this This new law is a little bit easier, I think, than the last one. It requires the labor commissioner in California to develop a model list of employee rights and responsibilities under the existing whistleblower laws, right? Once that list is developed, the labor commissioner is going to publish it on its website. Employers will be obligated to prominently display that list. It has to be posted in an area employees frequent, where it may be easily read during the workday in lettering larger than size 14 point, and it must include the telephone number of the whistleblower hotline described in Labor Code 1102.7. That hotline is a hotline to the Attorney General's office. Again, so on this one, there's not a lot that employers need to do. Monitor the Labor Commissioner's website. They will eventually publish this model list of employee rights and responsibilities. Post it in the same place at your business that you have all of the other state and federal postings that are required. Break room, you know, sometimes businesses don't have a break room and, you know, it's outside the main office. It's in an area where employees are often there, they're likely to see it, they're able to see it, they're able to get the information. One of the things I tell employers too is take photos of your posters, take photos showing where they're at. Um, if you ever get into a claim, if the business ever gets into a lawsuit, something like that, sometimes it's necessary to show that we have these posters up, right? Here's where they were. You could see what they were. And when you save those photos, make sure to keep a date somehow of when they were taken, because it's not uncommon in a lawsuit to see people say, I didn't know what my rights were. I wasn't advised on them. I didn't actually get the employee handbook sometimes. And being able to show that there is a wealth of information sometimes available through the posters can be useful. The next new law is SB 1137. This is including intersectionality as a protected category. So California is the first jurisdiction in the nation to adopt the concept of intersectionality with respect to a protected category under the anti-discrimination law, that's Fair Employment and Housing Administration, which, as Jillian said, is now known as the Department of Civil Rights. The broader set of laws here are the laws that prevent discrimination, harassment, and retaliation on the basis of a protected category. To date, before this law, those were things like race, gender, religion, disability, national origin, ethnicity, things like that. And now intersectionality is going to be a protected category. As defined in the bill, I'm sure you're wondering, intersectionality is the understanding that different forms of inequality operate together, they exacerbate each other, and they can result in an amplified form of prejudice and harm. It captures interlocking or interrelated forms of discrimination and harassment that individuals can experience in the workplace and in society. Probably still have some questions on what that means. There's a diagram down here at the bottom that shows to some degree the concept of what intersectionality is, right? It's the idea that somebody, for example, could be discriminated against on the basis of a combination of factors as opposed to just one factor, right? Such as being a man who's Pakistani as opposed to just being a man or just being Pakistani. It's adding complexity to the nature of what discrimination can be, or certainly what the legislators believe discrimination can be. There was a case, this is actually an old case that I think to some degree demonstrates this concept. It's a 1976 case, DeGraff and Reed versus General Motors. 5 African-American women sued General Motors for a seniority policy that they argued targeted Black women exclusively. The policy at issue didn't fall under just gender or just discrimination or race discrimination. The plaintiffs had trouble alleging that white women in similar positions were discriminated against. And they also had problems arguing that African American men were discriminated against. But the subset of that, which is African American women, were treated differently, or certainly the allegations in that case. And I believe there was evidence to support it in that case as well, that that specific subset was discriminated against. So what does this mean for employers? Handbooks and training and employment policies should be updated. Intersectionality should be included in the discrimination, harassment, retaliation sections. Managers should also be trained on this new category. So they should understand that this is also an area, or I should say a subset of protected categories where there can be discrimination, and sometimes it's an issue of, the cultural mores, the cultural practices, and the perceptions that people have of these specific subsets. It is something that managers need to have a certain level of sensitivity towards, especially if you have a company where there's a lot of employees there. The next new law is AB 2499. This is time off and protection for victims of violence. It protects against qualifying acts of violence, which are defined as domestic violence, sexual assault, stalking, acts that cause bodily injury or death, acts in which a firearm or other dangerous weapon is used or brandished, and acts in which an individual uses or threatens to use force to cause physical injury or death. Employers of any size are prohibited from discharging, discriminating, or retaliating against employees because of their or because of the family member's status as a victim of this qualified act of violence, or for participating in the legal process. A simple example would be if there's an employee and they have a husband, a wife, a spouse, a sister, a brother, a child, a parent who is a victim of one of these things, or who alleges that they're a victim of one of these things and needs to go to court for that. There's also additional protections in this new law. Employers with 25 or more employees will be required to permit employees who are victims of a QAV or have family members who are victims from taking time off from work for certain purposes relating to QAVs. For example, if somebody who is a victim of one of those events needs to obtain medical attention, seek legal services, go to court, things like that. The employee does have to give reasonable advance notice of this need for leave whenever possible. If there's a court date coming up in 3 weeks, they should be providing the employer with that notice. Now, if that is not possible because of the situation, let's say it's an emergency restraining order or something like that, or medical attention, the advance notice is not needed in that case. The time off is unpaid. They can use PTO or vacation to take that time. There's additional obligations under this new law of reasonable accommodation. And I will say everything we've been covering on this specific law, some of this is already the current law. This has been updated, this has been modified, and there's new definitions and new requirements put into place. So think of this, I would say, as the overall legal requirements for if someone is going through or a family member is going through one of these events. An employer may need to reasonably accommodate that employee. That may include the implementation of safety measures at the business, potentially a transfer, reassignment, modified schedule, changed work telephone, permission to carry their cell phone at work, a changed workstation, locks installed, or assistance in documenting domestic violence, sexual assault, or stalking. That would be to the extent that it is something that impacts or takes place at the workplace, right? The employer does not have an obligation to help document things that are happening at an employee's home or things like that. The California Civil Rights Department is also going to publish a form notice of these protections no later than July 1st, 2025. The notice must be provided to new employees on hire, to all employees annually, anytime upon request, and anytime an employee informs an employer that the employee or the employee's family member is a victim of one of these events. Again, for this issue, handbooks and training employment policies should be updated. Most employers already have a section in their handbooks that covers things like this. If it doesn't include everything that we've talked about, that should be updated so that employees are advised of their rights. I will divert here a little bit for a second. Part of the reason why employers need to have employee handbooks is a little bit of what we talked about before, which is if you don't advise employees of their rights, one, in reality, they may not know about them. Or they may know about them, but there may still be an allegation that I didn't know I had these things. I wasn't instructed to have them. And that can play into a worse situation if there is some kind of an employment claim. Managers, again, should be trained on this new category and the rights that employees may have. I will say that to the extent that certain things are requested by an employee relating to this new law, the employer does have the right to get proof of certain things. For example, if the employee says, I need to have a modified work schedule, and that's going to be a burden on the employer, then the employer has the right to get some proof of what's going on, right? Here's the restraining order that was filed, right? Now, I would say approach that process if it needs to be engaged in carefully, just simply because it's a sensitive issue for people. Obviously, there may be sensitive and private information involved. So um, be cognizant of an employee having concerns potentially about sharing information. Employers should also monitor the Civil Rights Department website for this new notice and use it when that's available. The next law is SB 1100, driver's license discrimination. Employers in California are now prohibited from including statements in job advertisements, postings, applications, or other materials requiring applicants to have a driver's license. The exception is when the employer reasonably expects driving to be one of the job functions for the position. There's another step to it, though, which is the employer has to reasonably believe that alternate forms of transportation for that job function would not be comparable in travel time or cost to the employer. That should not be an issue in most cases where an employee is specifically being hired, for example, as a delivery driver, right? AB 2123 is the next law. This is paid family leave, which is something that has been available for some time in California. It was previously allowed, but employers are now prohibited from requiring an employee to take up to 2 weeks of their earned but unused vacation before they receive benefits under the paid family leave program. So this is also something that should be incorporated into handbooks. Um, Not every company that we represent even does this, but if you work at a company where employees are required to use their earned vacation before they're allowed to take paid family leave, that process or that policy should be changed. Um, Separately but related, in California, vacation is considered a wage. As the moment it's earned, it's considered a wage. And so it has a lot of protections under the labor code. And so I always tell employers, be careful about doing anything with vacation unless it's very clear that you're legally allowed to do it, because the law and courts will treat it as you're doing something with the money that an employee's earned. Handbook, like we discussed, handbooks, policies should be updated. Managers should be advised that this is no longer a permissible practice. SB 988 is the freelance worker protections. These are independent contractors. They use the word freelance worker. I don't know why they didn't use independent contractor, but that's what they called it. Hiring parties, which they can't call it employers, because if your company's engaging an independent contractor, you're technically not an employer. That's what you're trying to avoid. So the business would be the hiring party. Generally, you may have an individual who could fit that definition, because hiring parties are any person or organization that retain independent contractors to provide professional services. These hiring parties are now required to pay independent contractors, if the services are above 250 or more, on the date specified by the contract, or if not specified by contract, no later than 30 days after the completion of the work. That seems relatively fair. Um, I have seen it be an issue. Um, and the reason, we'll get into a little bit the dangers of not doing that. But hiring parties are also prohibited from requiring an independent contractor to accept less compensation than specified by the contract, right? So the events where a business might say to a contractor, hey, we're going to have trouble paying you, or this stuff wasn't done when we thought it was. Um, will you take XYZ rather than what we agreed to pay you, right? That's going to get more complicated. That can still be done. It should be done in the context of, from my perspective, a legal settlement agreement. Um, there's certain things you can't waive under the law, but if you have a contract, those types of claims can be waived. But this new statute is going to give independent contractors additional grounds to allege that it's been violated, that a hiring business has done something that is prohibited under the law. So again, hiring parties cannot ask them to accept less compensation. They can't ask them to provide additional goods or services. Now, obviously, if you say, we would like to hire you for this additional scope of work, there's nothing wrong with that. And these independent contractors cannot also be asked to grant additional intellectual property rights that they may own as a condition of timely payment. Hiring parties and independent contractors must enter into a written contract that the hiring party must keep for no less than 4 years. Nothing in this law, however, amends or alters existing law regarding the appropriate classification of individuals as independent contractors. We'll look at that in a little bit. But if these new laws regarding freelance workers or independent contractors are breached, they can bring a civil claim for significant penalties and relief. That includes the attorney's fees they expend, the costs, additional penalties, and probably the biggest one is, this is, I think, a big takeaway from this, which is if the contractor isn't paid on time, they could bring a claim for double the amount that they're due, right? The statute does not make a distinction between a day late, 2 days late, or 2 months late. Now, it may be interpreted by case law, but as it's written right now, that's what it says is a civil claim can be filed by the independent contractor if they're not paid on time for all of these things, including double the amount due. So there's some real teeth in this statute. Hiring entities are also prohibited from discriminating against an independent contractor in any way for opposing any practice made unlawful or asserting any rights granted by this new law. They cannot waive any of these protections. So they can't say in the contract, I'm letting these things go. I will not seek recovery of. Now that is, I will say, that is different from whether or not there's a legal release in a settlement agreement later. A waiver ahead of time is different than saying, okay, we've come to a resolution. This is what it is. We're going to pay this contractor XYZ, and they're going to release their claims. Right?
Hey, Derek, we have a question that's come through. And this is regarding paid sick leave. Um,
Mhm.
is is it for long-term leave or is it also day to day where someone calls in sick but does not have any paid sick leave remaining?
Is this in reference to the paid family leave that we looked at? Or
I think so. For the person that asked this, feel free to chime in again, but I believe so.
okay. Um, The reason I ask is sick leave to some degree, well, to a large degree, is its own separate area of law with its own requirements. Paid family leave is actually something that the state will provide. So what we looked at previously, just to clarify, and I hope I'm getting this right, we looked at the issue of whether or not employees could be required to use up to 2 weeks of their earned vacation before they're allowed to take paid family leave. The new law says, nope, you can take paid family leave, no requirement to do that. That doesn't really impact the issue of sick leave. Sick leave is a different issue. Employees have their hours that they get every year through sick leave, either in a lump sum up front or they accrue it over time. Nothing in any of the laws we've looked at so far modifies any of the rights under sick leave. And I don't know that I'm answering the question, but I just kind of wanted to set that framework.
Perfect. Thank you. And again, if there's any clarification that this person needs, feel free to write in again. We do have another question that's come through as well, Derek. I understand there was a bill pending that would double the statute of limitations in California. Can you clarify what the statute of limitations um, are in California?
Yeah, as far as I know, that bill has not passed. I have not checked on that recently, but I don't think that passed. Statute of limitations can be a complicated issue, and it depends on the claim that's asserted and the relief that's asserted. Um, for in the employment context, the longest statute of limitations you're generally going to see is a contract claim. If you got a written contract of any kind and there's a breach of that contract, the statute of limitations is 4 years. So if you have a CEO, CFO, high level employee, or any employee that has an independent contractor and they're claiming that contract is breached in some way, it's a 4-year deadline to file suit. Most of there's differences against amongst claims. There's a lot of different statute of limitations, but the vast majority of labor code claims, meaning I didn't get a meal period, I didn't get a rest period, I didn't get overtime, the majority of those are going to be 3 years. There may be some nuances depending upon what the claim is, but for the most part, 3 years. So someone says, I wasn't paid overtime, and it's 5 years later, they're very likely not going to be able to pursue that claim, right? Almost in all circumstances, they're not going to be able to pursue that claim. Now, there's a complication to that, and you don't see it much with employment law, but if an employee, if somebody is taking action to deceive somebody from knowing what their rights are or what has actually happened, that can in some cases extend the statute of limitations, right? So if an employer is, you're not going to see this the vast majority of the time, but if you have a business that happens to be deceiving their employees about what their rights, some specific thing happened, you could see an argument that the statute of limitations is extended for that. Um, Additional complication on this, if you are filing under Fair Employment and Housing, again, this is what we talked about with discrimination, harassment, and retaliation, you have to go through the administrative process first. You have to file a claim with the Civil Rights Department before you go to court if you want to assert claims under the government code. The reason plaintiffs who are employees want to assert those claims under the government code is if they recover, they get attorney's fees and costs. So it makes that claim much more powerful. Those have to be done within 1 year from the date of the event, right? So some harassment occurred on a certain date. They've got to go to the Civil Rights Department, file their administrative complaint. It's not the same thing as a lawsuit. Sometimes there's not a lot of information put into it. Sometimes there is. In many cases, the employee will file that administrative claim and then right after just request a right to sue, right? Sometimes they just want to jump through that hoop before they go to a civil case, right? But if they don't and they just file it with the Civil Rights Department, in certain cases, the Civil Rights Department will look into that and investigate that claim on their own.
Wonderful. Thank you so much. And we did get confirmation that you answered the previous question perfectly. I do have one last question for you before you continue on regarding sick leave. Um, is there a statute? For example, the employee was in the hospital for a couple of days in February of this year. They used their PTO as they weren't aware that they had sick leave until July 2024. Can the employer decline to change the PTO to sick leave days?
And this happened how long ago?
February is when they use their PTO instead of sick leave.
So I would probably want to, if I was handling this as an attorney, I would want to know a fair bit more information, right? Because some of it turns on the issue of, did the employee just not know that they had it? Were they told that they couldn't use it, right? To the extent, I'll say it in a broad way, which is to the extent a plaintiff employee can allege any kind of wrongdoing on the part of the employee, there's likely going to be a claim. To the extent they can even allege that the employer didn't know its own legal obligations and didn't advise employees of those obligations, then there's potentially a claim there as well too. Um, some of it depends on whether or not there's a handbook, right? What did the handbook say? What did the handbook allow? But if the employee had sick leave and just wasn't aware that they had sick leave and asked to use vacation instead, and there's no wrongdoing on the part of the employer, my general advice likely to a client would be let them use the sick leave. And I say that largely because there's a lot of employment claims in California, and that's just one of the areas where I don't think the cost to the employer is probably that substantial. And you avoid I mean, look, the claim isn't going to be that significant, right? The claim by the employee would be, I had XYZ hours or days of sick leave and I wasn't allowed to use it when I should have, and I lost a vacation. So the damages from that are really just what the PTO is that they lost. That's the argument. And I'm not even saying that that's an ironclad winning argument. So it's not a lot of money. Are they likely to file a claim over it? Probably not. But could they go to the labor commissioner? Probably. Um, could you get an employee that causes them to do something else? Potentially. Um, that would be my approach with that one, which is if we're talking about a day or two of sick leave, I'd probably say let them use it.
Wonderful. Thank you so much.
No problem. And again, part of it is the issue of PTO and vacation are treated the same under the law. They're considered wages. And so their wages are being taken when in reality they had sick leave. The employee is going to say, hey, the employer should have known about this. They should have had HR. They should have had somebody that knew that and took it out of the sick leave first, right? The response is likely going to be, this is what you asked for. We did what you asked for. That's likely to be the scenario. Um, but people remember things differently and also present them differently in the future. So jumping back just a bit to the freelance worker new law, make sure independent contractor contracts are being used. We still see clients sometimes or businesses that are not using independent contractor contracts, and make sure they're very carefully drafted. And that's for a reason related to, but different than what we've even talked about. Make sure that payment terms are followed to a T, again, because as it stands, that new law makes no distinction as to how late the payment is. Um, we had a client a while back that an employee was not paid. I believe it was like 8 hours past, when it should have been, and they immediately filed a claim with the labor commissioner. You will get things like that, and it causes disruption of time and loss of resources. So, because this one has those penalties attached to it, make sure payment terms are attached. Terms are followed to a T. The related issue with this is make sure independent contractors are properly classified and their contract has all required terms. This continues to be a big issue. I'm guessing everybody here has probably heard of AB5, potentially even the Dynamex decision, and the current state of the law in California that makes it very challenging to be an independent contractor. So I wanted to look at that for a second here, just because it's related, and it goes to the issue of what these independent contractor contracts should state. A worker in California currently is presumed to be an employee. So someone's hired, it doesn't matter how they're paid, it doesn't matter what their title is, it doesn't matter even that that person thinks they're an independent contractor and wants to be an independent contractor. If they later change their mind, they could be held to be an employee, and they will be an employee unless the hiring entity, the business, meets all these three requirements. So the worker has to be free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of work and in fact, meaning the contract has to say that this person or this business who's the contractor is free from control and direction of the business. And then in reality, they also have to be that, right? If somebody's being required to show up to the office every day at 8:30 and work till 5:30 or whatever it is, it's going to be hard to argue that. The second factor that has to be met to show that somebody is not an employee is they perform work outside the usual course of the hiring entity's business. Meaning, take a law firm, for example. For a law firm, we have people that practice law, we have paralegals, legal assistants, office assistants, financial people, things like that. If we hire a company or a person to do marketing, that person may be outside the course of the hiring entity's business. And the third one is this person, the worker, is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. If a marketing consultant who has their own marketing business and advertises it, they have a website, they have other clients and customers, right? That is very likely going to be considered an independently established trade, occupation, or business. But employers have to be careful about what you try to fit within that, right? You go out and hire A construction company to do work on your building, it's very likely an independently established trade, occupation, or business, depending on the facts, right? But there may be things that don't fall within that. I've seen businesses hire financial people to do work in their business, and the person winds up working in the office, but they are a financial consultant and they have their own business. That starts to blend things to some degree, you know. Think what you would typically see with a separate, independently established business, and the more that the hired party meets that perception and those requirements, the more likely they're going to be an independent contractor. If anybody needs it, the Department of Industrial Relations has a good outline and answers to frequent questions on whether or not somebody's classified properly. It's at this. You can also search Department of Industrial Relations independent contractor on Google. It should bring up this website as well. It's a pretty helpful website, and it walks you through a pretty good overview of helping determine whether or not somebody is an independent contractor. There are various exceptions to AB5, and most of these are under labor code. So AB5 became a labor code, and then it was modified, and the newest one is labor code 2277. There's various exceptions to the idea that somebody is likely going to be an employee, and it's kind of an eclectic mix of professions. It includes real estate appraisers, home inspectors, musicians, landscape architects. There's other professions and trades included within that. So certainly if the business that you work for is going to hire somebody, if the person is expressly listed as an exception to the AB5 requirements, they can be an independent contractor. They are limited, the exceptions, and they're generally, courts narrowly interpret them, right? A real estate appraiser has to be a real estate appraiser. It can't be something that maybe does real estate appraisal work, but really does something else as the majority of their business. One of the other exceptions to the employment status provided by current California law is a business to business exception. And we see a lot of companies using this or attempting to use it. It is complicated. It has a lot of requirements to it. And so because it is still something we see a lot of, I thought we could go through what these requirements are. So the concept of business to business exception is the company is going out and hiring an outside independent business, right? And that business, it's a business to business relationship. We're going to have a contract. They do their own thing. They have their own advertising, marketing, their own offices, everything like that, right? This does not have to fall within the exceptions of the specific industries, but it does have to meet these 12 requirements. The business service provider has to be free from the control and direction of the contracting business entity in connection with the work under the contract and in reality as to how it worked. That was already something that was in the test previously. The business service provider has to provide services directly to the contracting business rather than to customers. This is a tricky one. The statute's been modified such that this requirement does not apply if the business service provider's employees are solely performing the services under the contract under the name of the business service provider, and the business service provider regularly contracts with other businesses, right? So think of a caterer, right? A caterer comes out to a hotel, does, let's say, some work for the hotel that perhaps the hotel doesn't have the capacity to handle at that time. As long as that service provider, they can provide services to the customers of that hotel, as long as they're doing it under the name of the business service provider and they regularly contract with other businesses. So they're a standard, legitimate catering business. They do this for all sorts of other companies. Third requirement is the contract with the business service provider has to be in writing, has to specify the payment amount, rate of pay, services, and the due date. If the work is performed in a jurisdiction that requires them to have a license or a tax registration, that service provider has the license or the tax registration. Again, think that really all of these elements with in this statute are they want to ensure that this business to business relationship is an actual business, right? Sometimes you will see that to try to get around the employment issue, people will have a service provider form an LLC, but really it's not a separate business. It's simply an LLC, and it's one person, and they're working out of their home, all that kind of thing. That's what these requirements are trying to avoid. So the fifth requirement is that the business service provider maintains a location that can include their residence that's separate from the business or work location of the contracting business, but it has to be an actual business location. The business service provider has to also, this is one of the requirements in the statute itself, customarily engage in an independently established business. Number 7 is that service provider can contract with other businesses to provide the same or similar services and maintain a clientele without any restrictions from the hiring entity. This is a complication you see sometimes where, if you hire somebody who's a business, they can go out and work for businesses doing the exact same things. Now, separately, you can protect your confidential information and your trade secrets and things like that, but you can't stop them from doing work for any other companies, even if they're a competing company. Number 8 would be the business service provider advertises and holds itself out to the public as available to provide the same or similar services. A website's great. That's great proof of it. Testimony regarding marketing events they go to, business cards they hand out, word of mouth referrals, if that is something that they're doing. But just make sure that service provider is also offering themselves to the public. The business service provider has to provide all of its own tools, vehicle, equipment, not including proprietary materials that the hiring party may need to provide. They have to be able to negotiate their own rate. They set their own hours and set their location of the work. And lastly, the business service provider can't be performing contracting work. There's a whole separate statutes that apply to contractors and subcontractors. Again, hiring an outside marketing company or outside bookkeeper for a company that doesn't do marketing or doesn't, engage in the business of bookkeeping as what they do, assuming these requirements are met, would meet that requirement. It would be a business to business exception. As long as the contract spells things out properly, they're not an employee. The last thing I wanted to look at is Private Attorney General Act lawsuits, PAGA lawsuits. I imagine most people have heard of them. They are in some ways like a class action. It is a lawsuit that is started often by just simply one employee. They can be started by one employee, and it brings in every other employee to the business who may have suffered labor code violations. These lawsuits seek the recovery of penalties for labor code violations, whether it's meal breaks, rest breaks, overtime. It could be misclassification. It could be incorrect pay stubs, anything covered by the labor code. So the PAGA statutes changed going into 2025. They are different now. They are more balanced overall. They provide businesses with a way to respond to these lawsuits and to deal with the issues addressed that are more favorable for employers. However, we're still seeing them being filed. I will say that in almost all cases in which they're filed, the attorney on the other side is seeking a company with a relatively large amount of employees, almost always, where labor code violations repeat each pay period, right? If there's only one employee and the violations are sporadic, it doesn't usually wind up adding to that much in penalties. If you have 50 employees and there's a violation that happens every pay period, it can add up to a lot, right? If let's say those employees are routinely taking meal periods late, right? And one employee says, well, I couldn't take meal periods on time because we were always too busy and I was told I had to stay on the job. That employee can file a lawsuit seeking to recover, and that lawsuit will draw in every employee that may have those violations. These statutes are an improvement, but they require a lot of upfront work. That's probably one of the biggest changes from the old law is normally with a lawsuit, things don't always kick off with a bang, and sometimes they do, sometimes they don't. Sometimes there's not a lot that happens at the start of a lawsuit. With the PAGA statutes, the new ones, a lot of work is required by the employer upfront and often before the lawsuit even gets filed. So these actions start with a letter, a notice that the plaintiff sends to the labor and workforce. Um, Employers can cure, meaning completely fix certain violations that has to happen within 33 days. And by cure, I mean if there are violations, they have to be paid out. Um, so cure is completely taking care of that violation. That's got to happen fairly quickly. And sometimes there's a lot of complexity in going through pay and time records to figure that out. There's another second deadline, which is within 60 days of that letter. An employer can take all reasonable steps to comply with the labor code. This does not require payment of violations. It doesn't require, an admission that things have happened, but it is changing things so that they don't happen in the future. And that again has to be done within 60 days. Um, these steps that employer can take, which in every case we've ever had, I've always advised employers to do this, um, because it caps the penalties that can be recovered at 30%. So it cuts the potential recovery if the employee prevails substantially. And this is instituting new policies on the issues that there was a problem, uh, having a compliant employee handbook, new forms, periodic payroll audits. All of the things on here are actually listed in the statute. So the general practice is follow what that statute says, and it's going to work out a lot better in terms of making the argument to reduce those penalties. A payroll audit would be on a quarterly basis. Somebody looks at perhaps a sampling of pay and time records to find out, hey, do we have violations that are occurring here, right? Now, a lot of businesses do that anyway. It includes manager training on these issues and possible disciplinary action against managers that don't follow these things or that are committing violations or allowing them to be committed. Again, has to occur within 60 days. Do everything the company reasonably can to fix the issue, make sure it will not happen going forward, and we're done. Thank you all.
Wonderful. Thank you so much, Derek. Love the picture. All right, so we are going to go ahead and open it up to additional Q&A. All right, we have one. Is a business legally required to have an employee handbook?
Um, so a business is legally required to have certain policies and certain information provided to employees. And some of that we looked at in some of the new statutes we had. So the question, I think, that goes with that is, well, what happens if we don't, right? There's certain things that employer has to advise an employee of. There may not be a right to sue on those things, right? Like if sick leave, for example, right? If employees don't have a handbook that tells them about sick leave and provides them with their rights, there's no express right to sue just on that basis. What I will say is it is legally required, and if the sick leave is not addressed and there's a problem with it and there's a lawsuit and there's no handbook, it is a disaster, right? Because it hands that employee the ability to say, you didn't even have a handbook, you didn't comply with the law by notifying me of these things, and as a result, all this damage happened to me, right? So it's more what you see in actual practice is it's more an issue of whether or not it makes a lawsuit more threatening than it should be. And I will also say the converse of that is true. If you have a really good employee handbook, I'll give you an example, meal and rest breaks, right? That's common that people claim that they may not have gotten them, right? It's hard to prove later. If you have a handbook that says, if you've missed a meal or a rest break, we want you to take them. We want to know about it immediately. If you haven't taken one, email HR at this email within 24 hours, 48 hours, so we can look into it, right? That's a very powerful thing to use in a lawsuit if people haven't notified you. And then a year later, they claim they didn't get rest breaks. It's like all you had to do was send an email, but you didn't. And we told you that, right? That can make defense of a lawsuit a lot easier.
Wonderful. Thank you. A question here. If employees work a 12-hour day, can they waive their second lunch?
You can waive your second lunch as long as you meet all the requirements for waiving the second lunch, and they haven't already waived their first lunch. The big issue with waiving lunches, I would say look at one of the best things to do is look at the actual wage orders for the industry you're in. Wage orders are very similar. You can find them online. The state has wage orders, but there's a specific wage order for each industry. There can be some nuances to how it works, but it covers this issue for all industries. So it's good for employers to have those wage orders, know what it says about these things. If you meet the requirements for waiving that second meal period, again, assuming that the first one hasn't been waived, you can't waive both of them. Um, then they certainly can waive it. And the only other issue tied to that is get some proof of it. Have a logbook that has employees sign saying, I have chosen to waive my second, meal period on XYZ day. Something simple, and they just simply sign off on it. Because again, proving it a year later, that's usually the issue.
Thank you. We have a lot of great questions coming in. If an employee has an open workers' comp claim and is on light duty, can the employer fire the employee if they refuse to do the light duty tasks?
It's something I would want to know more. It's something where I'd want to sit down with the business and really kind of dig into the facts and understand why they're refusing, right? You'd also probably want to, I'll say this, it's a workers' comp claim, but it also almost immediately in all cases draws in disability laws and including disability discrimination, retaliation, and harassment. That's how workers' comp things sometimes turn out to be a much bigger threat than they should be. Is something goes wrong and they have light duty, and then there's a dispute or an issue over that, and then the employee says you didn't reasonably accommodate me, you didn't do XYZ, right? So it's going to depend heavily on the facts. But one of the things often is in the right way, getting further information from that employee's healthcare provider, right? You can ask an employee to provide the light duty requirements or job description to the health care provider and ask that healthcare provider whether or not they think they should do it, right? And I say that because the doctor is often a good witness either for or against the business. If the doctor is saying, yeah, you can do these things, I see no issue with them, and the employee is just saying, I don't want to do them, yeah, after you go through the interactive process, I wouldn't go to the termination quickly because disability issues require this interactive process. You got to do because it's California, you have to do everything reasonably possible. You want the business to look like it is the most reasonable and reasonably patient company as it possibly can be. Meaning, we went back and forth on this, we documented it, and at the end of the day, this employee is simply refusing to do the duty, despite the fact the doctor has said that they can do the duty. Well, the doctor is likely a witness for the company at that point, and if it's just purely personal preference as to the light duty, then no, they could be let go. Now, there might be a situation where that employee says, well, you also have other light duty that is something I'm better at and pays more. That you might need to look at that as a potential option as well.
Thank you. Another question. I know we have to authorize meal periods, but if an employee doesn't take it despite reminders, is the employer on the hook for that?
That's a heavily contested and litigated issue. And yeah, legally, the way it stands is there's a case called Brinker versus Superior Court, California Supreme Court, that addressed this in quite a bit of detail and is always relied on. And the idea is employers don't have to police the workforce, right? They don't have to go around and go get up off your desk, go take a meal period. You have to do it, right? People are just choosing not to do it. But the reality of it is, if there's a lawsuit or a claim on it, people say things that are different from what the business is going to remember. They're going to say, "Oh, so busy all the time," or you know, you hear sometimes, "Well, my manager didn't like it when I would take meal periods," right? You know, you see all those kind of things. So what I would say is have a handbook that goes over and above that says, "We want you to take these meal periods. We want you to take these rest breaks." And again, if you're not able to, send us an email, right? Because then there's an electronic record of everything, right? The problem with a lot of lawsuits becomes, well, I was going to take a meal period, but my manager was like, give me a frown and said, we're really busy right now, right? And I didn't take it. And so I just didn't ask for the rest of the week either, but I didn't get to take one then, right? It becomes this he said, said type of situation that you want to avoid. So do everything reasonable to encourage people to take those breaks. I would say go above just authorizing them, encourage them to, right? And provide a mechanism that they can report it if they're not able to, right? Now, if you get a situation where you're noticing, hey, on this employee's time records, they're never taking a meal period. What's going on here? That's probably going to require some further investigation to find out what's happening there. But that's the way I would approach it. If you've got evidence showing that you've advised them, they're able to take it, you've given them a reporting process, they've never complained about anything, right? Um, you're on pretty good footing. You're on strong grounds for a lawsuit. But again, I've seen companies where there are violations that repeatedly happen, right? Like some group of employees just routinely doesn't take their full meal period, right? That can get tricky. You need to look into why that's happening. Now, again, it may be purely a situation where the employees just don't want to, right? They don't want to take the full meal period, right? But you need to find out what it is because it can turn into being presented as something different later.
Wonderful. Thank you so much. Well, we are at 10:31, so I'm going to go ahead and wrap up these questions. But we know that questions do pop up after these sessions, and so feel free to reach out to any of us. I know that I'll be including Derek on our email to you that will have the slide deck and the recording link, so you can connect with him directly as well. But just thank you again, Derek and Crow and Decker LLP, for sharing with us today. We appreciate you all for taking time out of your busy schedules to join us for today's BenderU. Again, the session has been recorded, and we will be sending the link to the recording as well as the slide deck. Again, if you have any questions, feel free to reach out to us, but we hope you have a wonderful day and hope you can join us for a future BenderU. Thank you, Derek.
Thank you all. Thank you, Jillian. Thank you, everybody.